to consider something, and that something is that
What?
Richard Epstein is involved in this litigation that's still pending. And if Richard Epstein is involved, I wouldn't want to be on the other side, even if you're a compliant political class in the city of Chicago and the state of Illinois, trying to move this along to, you know, memorialize the Obama presidency for all to see. Richard Epstein, one of the best legal minds in the world, sent a note outlining just how potentially complicated this all really is and the infirmities that the city may have and the Park District may have with respect to how this is supposed to proceed, at least according to them and the Obamas, with respect to federal law dealing with historical preservation, environmental protection, transportation. Well, let's hear the case. This is very interesting. And by the way, I don't know about you, Amy, but I've heard recently from a lot of people. I don't know that maybe this is just serendipitous, but wait, what is the deal with that Obama Presidential Library, or Obama Land, as I call it? Is that happening? Is that going to break ground? When's that supposed to be up? People
Yeah.
have asked recently.
Well, I
So
think they're supposed to break ground in a few months.
yeah, I think maybe this fall, but maybe not. Richard Epstein is the Peter and Kirsten Bedford Senior Fellow at the Hoover Institution, the Lawrence A. Tisch Professor of Law at NYU Law School, Senior Lecturer at University of Chicago. He's been at University of Chicago a long time. And as much as I'd like to plumb the depths of his legal mind over impeachment, we've talked a lot about impeachment, so let's talk about this rather intriguing case. Professor Epstein, thanks so much for joining us again. Appreciate it.
Very nice to be here, and I'm certainly willing to answer your questions. Let me just start with the first point, which is every administrative decision that is made under the environmental statutes is subject to some kind of review. There are three statutes involved. One with transportation, which requires the approval of the Secretary of Transportation based upon the reports received. But they're very limited in the way in which you could give it. You have to make it very clear that this is the only way in which you could do something, and you have to consider under the statute three levels of care in following order. First, you must ask whether or not it's possible to avoid the damage to the environment by putting the roads in various places. Secondly, you have to figure out whether there's a way to minimize these particular losses. And third, there's a way to mitigate it. And as you can see, the first one is the biggest disruption, the second, the middle-sized one, and the third is the baby bear. And during the course of these hearings, it was said we don't have to consider the question of avoidance or mitigation at all because the city has complete jurisdiction to decide to close 4 roads, decide to knock down 1,000 trees, and to put up this huge structure right next to the lagoon, and that there's nothing the federal government can do about it. There has never been a case, and there are many, many cases, in which this claim of city autonomy or local autonomy has ever been established. And you look at the papers that the government submitted in all 3 of these reports, they do not cite or quote the statute, they do not cite or quote the regulations, they do not cite or quote any particular case that supports their particular position. And so it is not very difficult to put something together to say that this thing is fundamentally flawed, because what they did is they took a unified project, namely cutting down everything and putting up something in its place, and saying there are 2 projects. One is destroying everything, and the second one is putting it back, and we can't look at the destruction. Now, ask yourself the following question. People pass major environmental and historical preservation initiatives. Do you think they want to make sure that these statutes have no application for destruction, but only have an application for reconstruction? That's the position that the city has taken. And so what we will do is we will prepare letters to the Secretary of Transportation explaining why it's inappropriate, and file challenges in court saying that the disclosures and the evaluations that they have to make under these statutes of environment, the so-called NEPA Act, National Environmental Policy Act of 1969, and the Historical Preservation Act, they just fall short. So these are lengthy proceedings. I don't want them to be lengthy. I think they're very simple cases and they should end. But you cannot decide to do any construction whatsoever so long as there's any appeal going in any case. In
Well,
addition,
Yeah, so
Okay,
if I
go
can
ahead.
interrupt, let me just ask you. So obviously, with the Biden administration and the his cabinet members in charge of these federal agencies that are relevant. I expect you don't expect relief from, Secretary of Transportation Buttigieg, for example. So the court challenges. Just remind us where these court challenges stand and why they have been unsuccessful so far. The decisions that have been rendered on
The
these matters so
decisions that
far.
have never been made with respect to the three federal statutes that I'm talking about. They were made with respect to the claims brought under the public trust doctrine. But it's important to understand the grounds on which the case was lost. It was not lost on the merits, which says that you can't bring it again. There was a decision written by then Judge Amy Barrett, unanimous, which said that we did not have standing to bring this case because we could not show that we had a concrete and particularized interest, given the fact that the only interest that we had was an undivided interest that the public under Illinois state law has in all of its public lands. That means, in effect, you're free to file the case again and to do it. And we expect to be able to file that case and to get a very much more receptive hearing than we got the first time when Judge Blakely heard the case, because he was very, very limited on the amount of depositions and inquiries that he allowed before he made a summary judgment against us on what we said at the time were flawed grounds.
Well,
Those grounds were never considered by Judge Barrett.
How do you get around the standing issue this time, then?
Well, what happens is there are one of two ways to get around it. You could file it in state court, or you can change the pleading in federal court so as to allege particularized interest for individuals who used the park, which was not done the first time. Or you can claim that there's supplemental jurisdiction, the way it happened, if you remember Loyola, when they tried to build there about 25 years ago in 1990, actually 30 years ago now. What they did is they brought a claim under the Environmental Protection Act, and then they appended to it in federal court the state law claim. That's perfectly proper, and it turned out Judge Aspin, when he heard the case, only decided on the state law case, only used Illinois precedent, and decided on a project which was much more favorable to the public at large than this one, that it could not be done under the public trust doctrine. So the thing can be refiled again in either state or federal forum, and it can be filed either as a separate action changing the pleading, or it can be filed as a joint action. So this is not a case which by any means is over. And the thing to understand is so long as this litigation is ongoing, it turns out that there can be no construction that takes place unless you want to risk very major public fines and so forth. So those trees are going to stand until this is done, and I think we will win on the merits of all of these cases.
Well, playing devil's advocate here, it sounds like you don't want there to be an Obama presidential center because they claim they're going to break ground in August after 4 years of delays.
No, that is not correct. We have proposed, POP, and are working on plans to explain how it is that you could put an Obama presidential center outside of Washington Park, which is a far superior site for any access to the public at large. Getting into Jackson Park is a nightmare because the Griffin Museum of Science and Industry is already there. You're going to have to break down the roads, and that's not going to work. You're building next to a lagoon so tight that you can't even have decent entrances into it. If you go outside Washington Park, you're over I think it's either the red or the green line. You've got the bus line near it. You're very close to the freeway. You don't have to change any kinds of roads. And since it's not on parklands, none of these environmental protections apply. And we would be very insistent upon supporting an immediate effort to let the construction go place on that alternative site. So this is not an effort to keep the Obama Center out of Chicago or out of or anywhere else. It's just to keep it out of Jackson Park. And, I mean, why is it that you have to put something there when you could put it somewhere else? It's going to cost less. Remember, this city is bankrupt in many ways. If you try to figure out the direct and indirect costs
every way
and the subsidies given, you're talking about $500 million of money, of public monies, and foregone revenues going to build the Obama Center. That number just goes close to zero if you move it outside Washington Park. So by all means, the president is entitled to have a center in his name. It is not, by the way, a library. Libraries are public bodies, heavily regulated, and the structure that they wanted to put up in Jackson Park does not meet the requirements of the National Records and Archives Act, which is an important statute. So fine, build the center. and it's fine to build it on the south side. You'll have much greater community access, much greater economic development if you actually build it in the middle of a community which can be rebuilt. And you go into Jackson Park, there's no private land for development anywhere within a half a mile of the place in many ways. The nearest thing is Stony Island, and that's already heavily built up on one side. If you go up on the Washington Park side and draw a circle around the area, you can see all sorts of vacant land that can be put to much better use if you have the Obama Presidential Center there as a magnet to draw other people in.
And
but wait, I thought our tax dollars were not going to support this library.
That's wrong. What happens is they're not building the building. But what they are doing is they're ripping down roads, all right? And they're ripping down trees. The cost of doing that in the direct cost is probably somewhere between $175 and $200 million, and that's 2016 dollars, not today dollars. So you're going to have to do that. In addition, you're giving away for $10 of 20 acres of prime land in Jackson Park. Foregone revenue, if you try to sell that, would be in the order of about $10 million an acre. Now, I don't want to sell that land, mind you, but I certainly don't want to give it away for $10. And then there are all sorts of very ambiguous provisions under these leases as to who has to pay for making sure that the thing doesn't fall away into the lagoon. It's going to require having very extensive supports going down to bedrock. The studies have not been done to explain how far it goes, but the lease is very unclear as to the clearly millions upon millions of dollars that are going to have to be spent even on the most favorable assumption as to who is going to pay for those kinds of things. There are all sorts of knotty issues under the leases saying if it turns out that the building is unstable, who's going to be responsible for its removal, should that be required. So I think the answer is the city is heavily implicated on the financial side in this particular case. And none of these road destructions, none of these tree cuttings have to be done on the Washington Pass side. There are a few trees that will have to go down, but a few trees is far short of 600 to 1,000 trees. What the city has said in connection with the trees in Jackson Park is we're going to take down these beautiful old trees with the diameters of 18 inches, 24 inches, and so forth, and we'll replace them with saplings. And it turns out it's better to put in 2.5-inch saplings than 4-inch saplings because they take. But in the interim, of course, you're not going to have any of the benefits of habitat, and those trees are absolutely essential as breeding grounds for all sorts of trees and birds. It creates the entire ecology. And so better that you knock down 20 trees than you knock down 1,000 trees if you want to put the Obama Center up. That's always a loss, but every other major construction project, since it alters the soil, tends to result in the loss of trees. And so, I mean, we would certainly defend their right to do this under these circumstances because we think it's important for the city of Chicago that if Obama wants to bring a center here, that everybody do what they can to make sure that it's done in the right place. So this is not an effort to keep the center out of Chicago. Quite the opposite. Our program is a carrot and a stick. The carrot is Washington Park site, or the site near Washington Park to be more addressed. And the stick is saying that you've managed to violate every federal law when it comes to trying to put it in Jackson Park and the public trust doctrine to boot. And so at this particular point, you have to look forward to at least 4 or 5 different lawsuits that we can file, all of which are sound as far as I'm concerned. I've never seen an environmental statement, an environmental assessment that is called, which is weak as the one that was put forward by the city and the departments, the Federal Highway Commission and the Transportation and the Park District, as the ones that we've seen in this particular case. They are threadbare because they refuse to address any of the major dislocations on the grounds that they're quote-unquote just local issues. No precedent whatsoever for that anywhere in the law to call something local. There's at least one case that deals with it. And what it says is if you have an abandoned garbage dump in the middle of somewhere where a goose may drop down from time to time, it may not be subject to federal regulation. But if it turns out you want to put on anything of a major sort near a wall, near a waterway, including Lake Michigan, then federal jurisdiction always attaches. So this is just absolutely beyond the pale. And the reason they cite no authority is they have no authority to cite.
And if we were talking about the Ronald Reagan Presidential Library or Ronald Reagan land, of course, the city would be making the very same arguments against it that you're making with respect to Obama land in terms of who's really would be interested in playing politics here. But I wonder, with what you were describing there, Jackson Park versus Washington Park, have there been any recent settlement conferences on the topic?
No, I mean, it turns out that there really can't be any settlement conference whatsoever unless they're prepared to move. There was an earlier effort, which I was not involved in. There's something known as the Jackson Park Watch, which tried to talk to the administrator, to the Obama Foundation, and to the city. And they did propose a minimization program, one that I opposed. And I said, look, we don't have to close Cornell Drive. What we could do is we could reduce it to 4 lanes. We don't have to put the Obama presidential tower smack dab where it is next to the Griffin Museum, because you could put it a little bit further south and make sure that you don't have to close the midway going east towards Lakeshore Drive, which is what this does. You don't have to have this building at 235 feet high. You can have it at 70 feet high and so forth. Those proposals were all given, and they were all categorically rejected. And this would be my reaction. I were offered, even from the Obama's point of view, basically a free hand to develop a first-class site outside of Washington Park, or take this truncated version, which is going to be highly expensive to do, I would certainly take the Washington Park site. In fact, the statesmanlike thing for the president to do is to confess error and to move quickly to take another site, because these objections are not going away. They're not fictitious. If you start looking at the way in which the decisions were decided, you will see that on the merits, the only decision that was made against us was by Blakely in the court below on the public trust doctrine. And his attitude was that the doctrine was completely toothless. He said, so long as you dot all the I's and all the T's in the authorization statements from the city council, you've met your public trust requirement, which meant that there are no fiduciary duties at all. But normally when you start talking about a fiduciary, either a public or a private one, they have to manage public property with care. And that obligation resides on the city, whether it gives it to the park department or to the city council. And you can't dissipate an asset by giving it away to somebody for a tiny fraction of its fair market value. And they've been in violation of both of those requirements. It's only if you state the public trust doctrine as Blakely stated, so as to make it worthless in every case, that you can be in compliance with it. Because I can draft any papers I want, which will say that I can do this. I can make things clear, but you cannot, by making things clear, make them right, given the fact that this doctrine is the other way. So there was a case called Pepke, which said we have to allow these challenges, because otherwise the doctrine is going to be utterly vacuous. And he did not quote that language when he wrote his decision, and I can assure you it's something which is at the center of our particular case. The Illinois State Supreme Court said if this is public lands, people have a right to make sure that the public officials discharge their public obligations, and they can't do that if nobody has standing to bring a suit against them. Now, federal rule standings are different from state law standing doctrine, which is where this case got held up the first time round. But in terms of the underlying substantive merits, there certainly will be a forum before which these issues can be put forward in the way which has been authorized by the Illinois Supreme Court.
He is Professor Richard Epstein. I wouldn't want to go up against him in court. Good grief. Peter and Kirsten Bedford, Senior Fellow at the Hoover Institution, Lawrence A. Tisch Professor at NYU Law, and Senior Lecturer at the University of Chicago. The Obama land legal team better gird their loins. Professor Epstein, thanks so much for joining us. Appreciate it.
Oh, it's my pleasure.
Hey, you convinced me. Move it to Washington Park. And he joined us on our turnkey.pro answer line.
You've made the switch, and it feels so good. You've switched to Chicago's Morning Answer on AM 560. The Answer.
You have faced uncertainty and anxiety, and now your retirement is looming. You might be asking yourself, did I put enough away? Will I have to pay a lot of taxes? Will my spouse be okay if something happens to me? Total Clarity Wealth Management can offer answers and help alleviate your anxieties. With a professional team of financial advisors and CPAs, they can show you the way to financial readiness and keep you on track. Their philosophy is built on solid relationships and trust. With access to expertise in tax planning strategies, 401k rollover services, estate planning, they can help you be ready for anything and give you confidence. Call Total Clarity Wealth Management. Call 630-762-9352. TotalClarityWealth.com. That's TotalClarityWealth.com. Also, if you're a wealth advisor who believes you should be doing the right thing for your client and likes to build relationships, talk to Total Clarity Wealth about joining their team.
Securities offered through LPL Financial. Member FINRA SIPC. Investment advice offered through Total Clarity Wealth Management, Inc., a registered investment advisor and separate entity from LPL Financial.
Is it time to have your sump pump checked? Hi, this is John with Basement Flood Protector. I'm a veteran and the owner. Since 1974, we've manufactured the most reliable and highest quality products and provided unmatched basement waterproofing and sump pump service to the Chicagoland area. Most problems with water in your basement have to do with your sump pump. Maybe it's old, doesn't work properly, or you just need more capacity. Most pumps should be replaced every 3 to 5 years. With our pumps, we recommend replacement every 7 to 10 years. At Basement Flood Protector, we offer a complete line of sump, ejector, and battery backup pumps. Do you really want the hassle and huge expense of restoration? Prevent it and contact us to schedule one of our knowledgeable technicians to assess your equipment. The Protector line of pumps are the most reliable on the market. Go to floodnot.com. That's floodnot.com. Basement Flood Protector. Integrity is our foundation. Floodnot.com.
News, opinion, insight. This is AM 560, The Answer. WIND, Chicago. Streaming at